Good morning, and thank you all for joining us today. My name is Stephen Aquario. I'm the director of the New York State Association of Counties. I'm joined by Patrick Cummings from our office, our association counsel. We're very pleased to present to you today's webinar on hot topics and public sector labor relations. We're joined here from attorneys from Roemer, Wallens, and Mineaux. Specifically, we have Matthew Ryan, Elena Pablo, and Earl Redding for our morning presenters here today to discuss various issues affecting New York County and towns with respect to labor relations. Administering a local government is a very complex and very different from a private sector position. We have civil service laws and other state laws, the Taylor Law as it's known, which restrict much of the day-to-day operations and collective bargaining terms and conditions of employment. We have a very complex system of government at the local government level, including police, fire, public works, public health, mental health, landfills, sanitation employees, and many other local government departments, all of which funded through taxpayer dollars. It's a very complex and ever-changing world. Today's webinar, we're very pleased to present to you, will address issues concerning salaries, attendance, overtime, absences with pay and without pay, health insurance, disciplinary actions, and things of that nature. And we're very pleased to present this as the association throughout the year receives calls and inquiries trying to develop or ascertain information concerning these various topics. So we are very pleased to present this as an opportunity for you to ask questions that you may have, that may have come up on a local level, and we encourage you to submit those questions right on your computer screen, and we will pick up those questions at the end of the presentation, which will go about 40 minutes or so today. Our goal is to conclude this webinar within 1 hour, but we will also respond to the various questions that come in and perhaps post this presentation on our website at the end of today. So again, we encourage you to submit questions that have come up, because if they're coming up in your area of the state, it's just a matter of time before it comes to affect another county around the state. We have many counties that have joined us here today, and we're very pleased to have statewide participation from every corner of New York State, and we're very happy that all of you took the time to join us today. So at this point in time, let me turn it over to Matthew Ryan, attorney at law at Roemer, Wallens, and Mineaux, to start today's webinar. Thank you.
Good morning, and thank you all for joining us here today. Some of you know me in person or personally. Welcome to the webinar. What I would want to start with is just a brief overview of what the three of us are going to tackle today. As part of preparing for this webinar, we tried to put our collective experience together to come up with some of the issues that we see not only counties and towns, but every employer around the state facing with regard to collective bargaining and managing their employees. So I draw from a fairly wealth of knowledge in my past. Don't hold it against me, but I was in-house counsel for a labor union for 14 years, almost exclusively representing corrections and police employees. I then moved over to Roemer, Wallens, and Mineaux as a partner and have been there for approximately 6 years and handle all of the bargaining all aspects of labor and employment law with the firm, including collective bargaining. So in that role, I wanted to bring to the table some of the things that we're seeing out in the field with what unions are pushing today. It goes without saying that the framework of almost every deal that you're involved in ends up with wages and health insurance as the top two issues. So what I thought I would do is bring those two matters forward so that we could give you our view of where these things are going. I'm going to jump around a slight bit, but what has colored or shaped the landscape is, as we all know, since 2008, with the collapse in 2008, it took a long time for the economic side of this to catch up, and most counties, towns, and villages had a little bit of a delay and started seeing issues in 2010 with regard to economics. So in those years, and this is a little bit of a 30,000-foot overview because we're going to be talking about current trends, there were a lot of 0% raises, or what we called skinny deals made, which in our view were deals that were maybe 1 or 2 year deals with 1% raises or rollovers in their contracts. So from there, it started picking up. But another issue that we saw that came around in 2011 was the implementation of the real property tax cap. And since that time, what we have been seeing is that consistent 2% raises in most jurisdictions, with some trending toward 3% raises, but I don't know that in any jurisdiction that I'm in that we've hit 3% yet. So what we're seeing is many deals with 2, 2.25, 2.5, with typically 3 to 4 year deals. And some of the raises that we're seeing are driven jurisdictionally, where downstate we're seeing an uptick in some of the raises. Again, not reaching 3, but 3% add to base raises, but we're seeing those trend upward. In the North Country, which I do a fair amount in, the standard opening raise offers around 2%, and we've been hanging out there. So that's just a general overview of what percentages we are seeing out there, and I'll come back to that a little bit later. We have, if we could go to the next slide. So just as an overview of what we're seeing in health insurance throughout the state, and this is a slide from it's called from the Bureau of Labor Statistics, showing us percentage of local governments with 10,000 or more workers offering health insurance to retirees. And that's just one aspect of the things that we see out there. And as you can see over time, and since 2008, it's on the decline. And many times that decline is because of economics. And this is where a little bit of the collective bargaining issues dovetail into how health insurance is being treated. I'm in a fair number of negotiations where health insurance is legislated, meaning that is provided through resolution or practice within a jurisdiction, and many unions are trying to get those benefits placed in their contract. As we all know, that makes it a guaranteed vested benefit, and it can be the source of significant economic expenditures in the future. So we're fighting that on many fronts, and have been fairly successful in avoiding getting health insurance, retiree health insurance submitted into contract. In the 3 or 4 interest arbitrations that I've been involved in, one involving a deputy sheriff, the interest arbitrator refused to put the legislated retiree health insurance benefits into the award, making it part of the collective bargaining agreement. So that's one of the hot topics out there, is obviously securing future health insurance benefits. So in that, we're seeing a decrease in the number of employers offering retiree benefits. Many times they're shrinking what is provided to what we call new hires, what they will see later on in retirement, whether it's a reduced benefit or if it's a higher amount of premium sharing cost, the percentage the employee pay. They've also seen some restrictions in on new retiree eligibility, including years of service requirements, including some types of sliding scales where employees get more points for working longer. The more points that you get, the higher the level of health insurance you get in retirement, meaning how much the employer will pay. So we're sliding back from fully paid retiree health insurance in a lot of instances. Some of the other things that we're seeing in health insurance, and for those of you who aren't self-insured, we're seeing one big change in 2010 was the arrival of the Affordable Care Act and the various plans that were rolled out under those under the ACA. Many employers originally went to the platinum level plans. We're seeing those plans come in between $28,000 and $30,000 a year for the premium. And one of the big trends that I'm seeing, and I'm actually in, I think, at least 3 negotiations right now, where employers are pushing proposals to move to lower level plans, whether it be silver, bronze, gold. Ultimately, they're really pushing for the bronze level plans. That's doing 2 things in our view. First, it's saving money on premiums, but in addition, many of those plans come with an HRA, the health reimbursement account arrangement, where the employer is including the monies to cover deductibles, some of them fully covering deductibles, but retaining that money for later use, which has economically helped out a number of jurisdictions. And we're seeing the utilization rate in these HRAs in the jurisdictions I'm in between 60 and 70%, which is explains that employers are seeing a 30% savings when those deals can be made. Some other employers have moved to create consortiums. We're seeing that in at least one county, where a number of other towns and villages can join and enjoy the savings that may come with it. As far as the percentages that employees are paying throughout the state, percentages in blue collar and non-union are coming in around 15 to 20% of the premium. In some of the northern regions of the state, we still see some towns and villages where employees who are hired before a certain date are not paying anything for health insurance, which is somewhat of a rarity these days. Police and fire remain somewhat of the outliers, with a number of them still paying flat fees for health insurance and not a percentage. But that trend seems to be changing a little bit in a recent interest arbitration in the southern tier. The arbitrator awarded the employer a change from a flat capped rate to a percentage of the premium cost that the employee had to pay. So that was a cost savings to the employer in that jurisdiction, and that's what we're seeing around the state with regard to people trying to get the rates that they're paying up higher. One of the other things that we're seeing in trends in health insurance is that for those employers out there that have what I call our off-the-shelf plans, that they're not self-insured, some of the unions are trying to get stronger language in the contract to cement the rights that they would have under a plan that the employer doesn't administrate. What do I mean by that? They're trying to negotiate in strong language that says if there's a change in copay, the employer essentially has to indemnify the employee or negotiate the change. We're fighting those proposals fairly strongly because obviously we all know we can't control what happens with what the health insurance companies are providing and what the copays are, the fees or expenses. As far as retiree health insurance, as I touched on before, we're not seeing much in any way of any employers offering early out or change or lower rates for health insurance to help economics. And if we could go to the next slide, please. So just in looking at what we're dealing with regionally, we thought we would show you a report that the Empire Center put together. It's called What They Make. It's really, for as long as I've been in the business, there's no real shock to see what the wages are and how they shake out. Obviously, downstate and Long Island, we're seeing, police and fire far outpace the rest of the state, as well as some of the other metropolitan areas. This gives you just a general overview of what the breakdown is. Obviously, general employees make less than police and fire, with fire in most instances outpacing police in their wages, but for Long Island. Statewide average, as you can see, is about $54,000 a year across all New York. You can see where you compare as far as your salaries. If we could go to the next slide, please. We thought it'd be good for you all to see what general employees make vis-a-vis their actual economic region or their region of the state. It's somewhat self-explanatory of what we're looking at, and you can see where the trends are for wages are. Could you go to the next? I thought this slide was somewhat interesting because what it shows us is the salary trends across the state, and in particular 2018 and 19, and in large part, you're seeing those wages in a positive number at the far side there, down where it says percent change in 2018 and 2019. I think some of the negative numbers may be attrition or otherwise, but it's somewhat consistent with where we're seeing salaries go between the twos and cumulative raises. So in that regard, some of the salary trends that I spoke about before with regard to the percent raises, some of the other things that are unique that are new, and some of the proposals that the union has put together, and one in particular that I'm dealing with right now is that, and it's actually subject to an interest arbitration. It's a police outfit, and they're seeking EMT pay as well as certified first responder pay, which is something unique in my experience. And just by way of background, the employer is taking the position that first responder work is inherent in police work. They do not require police officers to engage in any EMT duties, and any of the EMT training is a voluntary matter. I don't know if anybody's seen any type of proposal like this in your latest round of negotiations. If you were, I'd be interested in the question or how you resolved it. Along those lines, another significant change happening at the late part of, the middle part of last year in August was the Janus decision through the United States Supreme Court. This decision held that it was unconstitutional to require a person to be a member of a union and to require the agency shop fee pay if you were not a member of the union. And the big takeaway from that case that we've been dealing with is the impact of what it means for the person to opt out in writing of their union membership. We've seen a number of jurisdictions who will leave it up to the union to cease payments. Some other jurisdictions have unilaterally stopped union dues deductions when they are presented with a denial, with a withdrawal of the union membership. So, what other issues has this caused? Many contracts that we're dealing with have agency shop fee pay language in the contract by Janus's very holding. Those provisions are unconstitutional, and in all the bargainings that I've been involved in, we have worked to remove that language, and in addition, we have sought to add indemnification language so that if an employee does opt out and the union fails to tell the employer will be covered for defense and indemnification going forward. Interestingly enough, when Janice came down, we didn't hear much from employers with regard to what do we do with our contract now that sections are void. Some people have left those sections void and have relied on the savings clauses in their contract to let the remainder of the contract operate. But in negotiation, as a result of that, when we do have the opportunity, we're putting these housekeeping proposals in to remove the Janice language. Another issue that Janice has arisen is that now that employees are non-union members and don't have to be part of the union, some of the grievance and disciplinary procedures are being amended to ensure that employees have access to those without the union, so that employers don't face lawsuits or other outside action by employees. One of the things that we've worked on is that to the extent that Civil Service Law Section 75 applies in your jurisdiction, the Janice decision in part has brought back the Auburn Police Local 195 case versus Helsby in 1979, where it says disciplinary procedures are mandatory subjects of bargaining, but if you're covered by Civil Service Law Section 75, you have to have a provision that allows for employees to opt out and into the Section 75. That's becoming a bigger issue because of Janice. So these are some of the hotter topics that we're seeing throughout the state. Obviously, the impetus behind these have been some legal changes, such as the Affordable Care Act, as well as the holding in Janice. With that, I'm going to turn the webinar over to Elena Pablo, who is a senior associate in our office, who has worked with us for approximately 6 years and has handled a number of labor and employment issues in her tenure. And with that, Elena, I'll give you the microphone.
Thanks, Matt. I'm going to shift gears here a little bit and go over a couple different issues with respect to employee leave, both statutorily required leave, leave under collective bargaining agreements, or other leave provided by the employer on their own. As we go through each of these, there's 3 categories I want to discuss. One, we don't have a slide on, but I'll talk about at the end an additional piece. And with each of these, I'm going to make sure I point out when we do have an employee taking leave for one of these various reasons, when they are required to use their own, if they have accrued leave under a collective bargaining agreement concurrent with these other types of leave. Some they are, some they aren't. But I'll make sure to note that because that's something we get a lot of questions about from our clients in terms of these statutorily required leaves. Are these running concurrent with leave that they already have? Certainly in the public sector, we've got a lot more leave entitlements than some of our private sector counterparts. So that's something we'll note as we're going through each of these. The first one I'm going to start with is the voting leave. I'll start with this one because this is the one that we got the most questions on from our clients, I would say. This is a change that went into effect earlier this year. For quite some time, New York State has allowed employees 2 hours of time off for voting to make sure they're enabled to vote, only if they didn't have enough time at the beginning or the end of the day, up to 4 hours before their regular shift to get to the polls and to vote. This law significantly amends that prior entitlement. We now have rights up to 3 hours of leave, and we've removed, well, we haven't, the state has removed that provision which says only employees who don't have 4 hours at the beginning of, or end of their shift are entitled to this leave time, opening it up to make sure that this is applied to anybody who needs time, enough time to enable them to vote, is how the statute reads now. And up to those 3 hours, which will enable them to vote. So we no longer have that benchmark of how much time does this employee have at the beginning or end of their shift to help us determine whether they're entitled to this additional leave provision. Most of you, or all of you, I imagine, have been through one election cycle with this new law already. We got a lot of questions from our clients prior to the last voting cycle as to, we know the law says the employee has to require the time off to enable them to vote. How do we know whether someone is required, needs that time or not? The law is conveniently silent on that point as to, is it the employee's burden to prove that they require this time to enable them to vote? Is there some sort of confirmation that they're supposed to supply us or some explanation for it? And of course, like I said, the statute does not give us any assistance there. So we had a lot of questions about that. I think there was, my understanding, a pretty wide variety of ways that employers handled this in terms of how much or how little documentation or rationale they had employees provide. Certainly, to err on the side of caution, you could not require anything. Just the employees have to give you 2 days notice. And some employers took that more conservative approach to say if someone comes to us and states that they need this time off to vote up to the 3 hours, they give us the required 2 days notice, we'll allow them to take that leave. As far as I can tell, no employers, at least that we deal with, have had a mass exodus of employees on election day as a result of this law, to the point where it would, shut down the county operations for that day in order to provide leave to everyone who requested it. Hopefully that's the case in your county. Other employers took a more aggressive approach. I know some counties have requested things like confirmation or affidavits or certification from the polling place. I suspect that we will see some sort of guidance, at least at the PERB level perhaps, from as to the issue of what certification can the employer require? Do we need to negotiate what that certification is? There are some areas under PERB case law where an employer may have a statutory right or obligation to provide a leave, but they have to negotiate aspects of how much the employee has to participate in that process. So this may be something that ends up at PERB in terms of, does the employer have to negotiate these certification requirements based on the open-ended issue with that under the statute. Another thing that the statute does not speak to is how this is going to interact with the new early voting rules that are going into effect later this year. So if an employee has now an expanded period of time to get to the polls or to submit their vote, when is an employee going to be required to take this leave time? That is another, again, as I said, an open issue, and some employers are taking a more conservative approach and erring on the side of providing that leave whenever an employee indicates that they need it, and others have been more aggressive. And I'm sure we'll see more guidance as we move forward through in a couple more election cycles as to what the employer's obligations or options are in terms of those certifications. The law also doesn't state whether this is a leave that can run concurrently with accrued leave time. Another law that we're going to look at in a second, the cancer screening law, has similar provision, similar language about leave off without loss of pay. And there is a case interpreting that statute which has said when we say leave for cancer screening, we mean leave without pay and without charging leave accruals. So again, to be on the more conservative side, I would say you may expect that a court would look at that voting leave provision and come to the same conclusion, that when we say up to 3 hours off with pay, that means with pay and without having to charge the employee's leave accruals. Another relatively recent change to statutory leave entitlements is with respect to cancer screening leave. The civil service law, this one applies specifically to public employers. The civil service law used to have two separate provisions, as you can see on your slide there, providing 4 hours of leave per year for breast cancer screening and a separate statute providing 4 hours for prostate cancer screening. The state in 2018 combined those two. We only have one statute now entitles an employee, a public employee, to up to 4 hours of paid leave per year for cancer screening. General cancer screening doesn't specify the type of cancer, so that's one of the provisions that has been changed. We did have a few clients which brought up the issue of they had employees who were utilizing 4 hours of leave under each statute prior to this consolidation. They were using up to 4 hours a year for breast cancer screening and also 4 hours per year up for prostate screening. Our advice has been we don't see anything in the law that entitles you to 4 hours per screening. It is 4 hours per year for cancer screening. However, the employee chooses to allot that time is up to them. Certainly they could use contractual leave time if there were additional screenings that they needed to have done. But until we see something to the contrary, our recommendation has been that employers apply that as 4 hours per year for cancer screening of any type, not 4 hours for each type of cancer screening. And as I said, there's a citation there to a Supreme Court case from quite a few years back, which found that with the cancer screening leave, this has to be leave off with pay without requiring the employee to charge any of their leave accruals. I know we have a few clients who have it in your payroll system or your timekeeping system as a separate leave category. So if there's a drop-down menu, sick leave, vacation leave, personal leave, there's a category for cancer screening, and that they limit that allotment to the 4 hours per year, but it's a separate leave entitlement, and I would suspect, if I had to guess, that the voting leave will end up being interpreted similarly to that. So the next issue that we've had, a recent issue with respect to paid family leave in New York State. As I think you all are probably aware, the New York State Paid Family Leave Act does not automatically cover public employers. Public employers need to be opted in, so to speak, to this coverage either through the union, through negotiation, or by their employer. We have not seen, as far as I know, I'm only aware of one county in the state who has opted their employees in, and I believe that goes for our smaller jurisdictions as well, cities, towns, villages. As I mentioned before, public employees have quite a bit of leave already, and because this is employee-funded leave, we're not seeing a huge push from unions to incorporate paid family leave in for their employees. The chart that you have on that screen is helpful for any employers who might be contemplating the opt-in or who may now or down the road get a request from a union to incorporate the opt-in paid family leave. It gives you kind of a summary of the types of issues that must be negotiated, can be negotiated. As it's not uncommon, you can't agree to provide the leave, but at a lower level than the state requires. In other words, it can't be for fewer weeks than the state requires. It would have to be equal to or above. You can certainly negotiate more generous benefits, but you can't negotiate it but at a lower level of coverage for the employee than the state requires. You can negotiate, if you'd like, to have the employer pay the employee's share of the benefit deductions. I don't know that we're seeing a huge rush to do that, but that is something that could be negotiated. If you were to, the way that the law is set up now is that these employee contributions towards the leave entitlements, much like short-term disability, are taken out each pay period. If you were to negotiate more maximum weekly contribution by the employee, that's something that you would need to get approval from the state, from the Workers' Compensation Board. And the next slide there, again, just for those of you who are thinking about it, gives you a summary. This is a leave provision that's phased in for 2019. We're looking at 10 weeks of leave at 55% of either the employee's salary up to the state minimum weekly wage, which is about $1,357 at this point. And the last piece I'll just mention, we don't have a slide on this, but there has been a change in the New York State law with respect to domestic violence victims, providing reasonable accommodation to domestic violence victims going forward, meaning providing, unless it would constitute an undue hardship, leave for them to seek medical attention for injuries caused by domestic violence, attain shelter services, counseling, psychological counseling, either for themselves or their children, participate in planning, legal services, things like that, unless it would provide an undue hardship. This is something that you want to make sure that you are training your supervisors, anyone who's at the front lines who may get these types of requests. We always want those individuals to know, not necessarily that they have to know the ins and outs of every law, but know enough when they get a leave request that a little flag should go off in their head if this is related to a disability, a pregnancy-related condition, and now domestic violence victim status, to get assistance from HR to make sure that you're complying with this new provision as far as leave that they might need for those services. That leave can run concurrently with leave that they might have under accrued leave under a collective bargaining agreement. And with that, I'll pass the torch one more time to Earl Redding. He's a partner at our law firm, and he's going to take you through a couple additional employee issues.
Good morning. Two of the issues I'm going to talk about are body-worn cameras and medical marijuana. The first issue is body-worn cameras. Over the last several years, we've seen an increase in the amount of agencies that are utilizing body-worn cameras in, with their deputy sheriffs and their police. We've also started to see body-worn cameras in the correctional facilities, not on a basis of everybody wearing it, but on a basis of the line and the employees on the line working with body-worn cameras. So over the past couple of years, Axon Taser had a really beneficial program to get those body-worn cameras out to the public sector. And as a result of that, we saw a proliferation of policies that were enacted by different municipalities, and they sometimes looked the same, sometimes didn't. The one thing that we can say that is the same is that policies implemented by the employer that have to do with body-worn cameras are not subject to bargaining from the get-go. And what do I mean by that? I mean that the employer can implement the policy, and then if the union does not agree with certain terms and conditions within that policy, they can choose to bargain the impact of the policy. We have some things here on the slide that talk about what's the general topics or terms and conditions of employment that are subject to impact bargaining. But I'll give you the reasons of why implementing the policy is not subject to bargaining. And that's because equipment that's employed by the employer is always seen to achieve its core mission and to provide services to its constituents. So it's non-mandatory. Again, the promulgation of rights, rules, and regulations, that's a management right of everybody. The direction of the workforce, directing the employees to wear the body cameras, that's a management right. The use of recording equipment, it goes to generally the core mission of the employer, and again, that's non-mandatory. And why do we have body-worn cameras? The body-worn cameras You'll hear from the union will say, well, it's always the capture us doing something bad. Generally, what we found from our employers and our clients is that the body-worn cameras are actually, they are being used to establish unfounded complaints. So somebody complains that somebody did something out in the public, where you go and you look and you see the body-worn camera and you notice that, no, that actually didn't happen, or it didn't happen the way the complaint is saying, such as the use of force. There might be a use of force complaint, and the individual makes a complaint. They don't particularly like this officer, and the sergeant will look at the body-worn camera and see that that didn't happen the way the complainant is saying it happened. So the body-worn cameras have been used in a manner to exonerate the officers, and we've seen it happen time and time again. Now, does it catch an officer who does something bad? Of course it does. The policies always have something in there that has to do with discipline, which is you see something on a body-worn camera, you can discipline the person. Now, discipline is a term and condition of employment that is part or could be part of impact bargaining. The rights of an employee and a union to review the footage in terms of completing reports prior to the disciplinary interviews is also something that is part of impact bargaining. There are two schools of thought on whether or not an officer should see a body-worn camera footage prior to their interrogation. So you go to do your loudermill of the officer, and there are some jurisdictions that will say, I don't want the officer to see the body-worn camera footage because I want them to testify about what they recollect, not testify about what the body-worn camera actually shows. Because sometimes it will capture things that the person acting didn't see. And then that could be part and parcel of their testimony and maybe change their testimony. Now, there's the second school of thought, which is, well, let them see everything, and if they did something bad, we're going to find it anyway, and let them testify about it, and we can also then question them on the testimony. So the impact bargaining in terms of discipline is a subject. Stipends or additional responsibilities for the maintenance of equipment, we have seen in certain policies where officers are provided with a stipend. I think one of the only ones that actually I've seen is down in the city. The dissemination of recordings by the employer, that has to do with FOIL. So your Freedom of Information law essentially says that everything is subject to disclosure unless there's an exception that applies, right? And the body-worn camera footage is something that some unions have definitely fought to have not disclosed. So something happens in the public, a member of the public says, I want to see that body camera footage, or the press says, I want to see that body-worn camera footage, and the employer will review that to determine whether or not it's subject to FOIL, right? The unions are saying that Civil Rights Law 50A protects all body-worn camera footage from being disclosed. Well, there was a court case. The court case was the de Blasio case. It's 169 AD 3rd 518. It was a First Department case in April of this year. We've also had a cite to the Prisoners Legal Services case from the 3rd Department. But that said, that 50A body-worn camera footage is not subject to 50A. It is subject, I'll give you two distinctions, one why it's not subject to 50A and one where it could be subject to 50A. The first distinction is you've got to think of body-worn camera footage as your arrest reports. That's what the court looked at and stated. Body-worn camera footage now is just your, it's real-time footage instead of the officer writing down a report what had happened. Reports are obviously something that is subject to FOIL unless obviously there's a privacy exemption that applies. Now the body-worn camera footage, if I ask to see the April 30th, 2019 at 6 o'clock, Earl Redding was working beat 207. I want to see the body camera footage on that. That may be subject to FOIL. Now, if during that time I committed something that was then subject to a discipline, where I was served with a notice of discipline, the body camera footage was part and parcel of that, and the press or somebody was foiling the body camera footage of that specific to the discipline, that may be subject to 50A. And why is that? Because that is part and parcel of the discipline. Just like if you were trying to foil something that was being used, the notice of discipline, and the actual discipline had not been come to a determination, that notice of discipline would not be subject to FOIL in that instance. So the body camera footage has been something that has been a hot topic, and it's been a hot topic because a lot of times, again, the unions are fighting against either having the policy implemented, or they're fighting against having the body-worn camera footage disclosed, or even fighting against having that part and parcel of the discipline. The second thing I'm going to talk about is medical marijuana. Medical marijuana has been an extremely hot topic since the Compassionate Care Act was enacted in 2014. Two of the things I kind of want to talk about that are really hot topics are, do you have to give a reasonable accommodation to somebody who has a disability, is a qualified individual, right? So they have to be qualified and they have to be able to perform their essential functions of their job with or without reasonable accommodation. But do you have to provide a reasonable accommodation to somebody regarding medical marijuana? And the answer is, I don't know, let's see. And what do I mean by that? I mean that New York State requires you, under the executive law, says that you can't discriminate against somebody with a known disability. It also says that you have to engage in the interactive process with somebody when they do have a known disability. So if someone has a known disability and is coming to you, and they're coming to you regarding their prescription marijuana, you do have to engage in their interactive process with them to determine whether or not there's a reasonable accommodation that will allow them to do their job. Now, if they are have a CDL and they're a MEO and they want to take their medical marijuana during the day and then operate heavy equipment, obviously that's something you're probably going to say no. That's going to impair your ability to do your job. The other thing is that the employers can still state under the Compassionate Care Act that you do not engage in illegal drugs during the workday, or that you're not impaired by illegal drugs during the workday. Is it difficult to establish and prove? Of course it is. Sometimes you got to bring somebody down who knows how to determine whether or not they are under the influence. But you got to think about it also like alcohol and opioids. A person could be impaired. They may be able to have medical marijuana. They may be able to do it after work, but they can't be doing it so that it impairs their ability to do the essential functions of their job while at work. One of the other things that we've seen with medical marijuana is I've seen it in the 207C context. And so what do I mean by that? So General Municipal Law 207C, right, says that an officer that's injured in the performance of their duties can receive salary and can be on leave with that pay for that salary. We've seen some officers that have been provided with prescriptions of medical marijuana, officers as deputies, corrections officers, and we have seen recently that those costs associated with medical marijuana are extremely high. We've seen some employers look and find ways of cost saving in that, and significant cost savings of up to $40,000 to $50,000 by switching to Canna RX. There are lots of different things that are involved in that, and whether or not you can switch, you'd have to look at your 207C policy. What we'd always say is have a conversation with the employee about the switch, as long as it's the same prescription. All you're really doing is cost saving for the county, and that's a win-win. So for my purposes, that's medical marijuana, some of the hot topics we've seen, and body-worn cameras. I think quickly, Matt's going to talk to you about some of the Taylor Law amendments, and then we're going to take some questions.
Hello again. As many of you likely know, that in anticipation of the Janus decision coming down in 2018, the state legislature, obviously with the governor's approval, amended Civil Service Law Section 208, which was previously the agency shop fee payer language that required non-union members to pay the agency shop fee. Other than eliminating the agency shop fee language, there were three main changes to this provision in the law. First was limiting the duty of fair representation. Public employee unions do not have to provide representation to non-union members in disciplinary cases. I've been in some jurisdictions where it's prominently posted by some of the unions that if you do not pay, we do not represent. So that can change the landscape a little bit when you're trying to administrate a collective bargaining agreement, a grievance procedure, a disciplinary procedure, and figuring out who at the end of the day, if anyone, is going to represent the employee. New employee notice, and this is something that I'm seeing out in the field that I'm dealing with in regard to proposals. Public employers are required to give notice to unions of new employees within 30 days of employment, and permit unions to access employees for a reasonable amount of time during work hours without charging leave time. And as you can imagine, the term reasonable has come up as part of a proposal. One union is out pushing a proposal that would allow the meeting to last for 45 minutes. Obviously, the employers that I'm dealing with are taking a stance that it doesn't need to be that long. That is something that that is out there. Generally, we're saying 20 minutes. Most employers already have an orientation process that allows the union access to the employee anyway, new employee. Another aspect of this that we're seeing is, which was another change, is unions are permitted to utilize electronic membership cards. The same union I'm dealing with has floated a proposal for contract language that says that the initial notice for existing employees can be through a list provided by the union. I have argued against those proposals because of what Janice has told us, is that the employee has to affirmatively opt into the union. So in any of those counter proposals, if we're even going to discuss it, the employee would have to provide some sort of authorization, not just a list. So those are the three big issues in the latest amendments of the Taylor Law. And with that, we'll entertain any questions there might be.
Okay, I'd like to thank our presenters for today's session. Now's the time for folks to type in some questions. Our first question that we'll take up here is dealing with retiree health benefits. Are we seeing any decisions, arbitration decisions regarding retiree health, perhaps segregating it from existing active employees and creating retiree health group plans or Medicare Advantage plans? Any decisions that anybody has seen regarding retiree health and active employees?
Sure. In attending the Taylor Law at 50 anniversary, there was a prominent labor arbitrator who had done a number of interest arbitrations over time, and he said interest arbitration is baby steps. So we're not seeing a wholesale rearrangement of health insurance for existing employees in retirement. There was, I believe, a recent case in, I want to say it was Madison County, through arbitrator Howard Foster, who, when I spoke about changing how you scored points towards getting retiree health insurance, made a move away from what the existing plan was, and interest arbitration changed it. That's the only one that I'm aware of recent note, and that was going back to around 2015.
Okay, the next question that we have is body camera footage part of an arrest record? If it is part of an arrest record, is it subject to the new discovery process, the new criminal justice reforms that require the governmental entities to share that with defense counsel within 15 days?
So for purposes of an arbitration, I would say that you would have to disclose the body camera footage at any point in time to an officer that you're disciplining. If you're the employer and you have body camera footage that is part of an arrest record of somebody who's a non-employee, it would be, again, just subject to the regular exemptions under FOIL. I think it would have to be disclosed, and then you could say if there's a privacy component towards it, where somebody from the public is asking you for it. If it has to do with if the officer, I recently saw in this weekend's paper that there was an officer arrested. If there was an officer arrested around here that has that body camera footage is being utilized, I would say that may be subject to 50A if that body camera footage again is being used as part of the discipline. But if there's no discipline pending, if it's just an arrest, that probably is going to be subject to just a regular FOIL and not subject to, and I don't think 50A would be an exemption that would apply.
Okay, so we're right up on our hour here, but we have a couple other questions. Elena, for you on voting leave. The first question here is, are counties requiring this leave to be used as employee accrued time, personal vacation, personal time off, or are the counties allotting this time off without the use of accrued time?
Sure. Yeah, that's a good question. That's a question we get a lot. My answer to that would be the statute doesn't say clearly whether, and the employer can require the employee to use accrued leave time for these 3 hours of voting leave. So the best rule of thumb that I can recommend for employers is that cancer screening leave, which is a similarly worded statute. Under the voting leave, we don't have a court decision addressing that issue yet. With cancer screening, we do. And with the cancer screening statute, the court said that you cannot require the employee to charge that leave time to accruals that they have, sick, vacation, personal, whatever the case may be. They said that it says without loss of pay, they considered the use of leave time, required use of leave time, a form of being leave with a loss of pay. So without a decision yet under the voting leave as to whether it can be charged to accruals or not, I would say erring on the side of caution that employers would not require the employee to charge that leave until we have more firm guidance telling us one way or the other whether accruals can be required to be used under that statute.
Okay, sounds like there's some precedent there. The next question, Elena, is there on this issue, has there been any guidance or consistency on what constitutes a 2 days notice by an employee to the employer for voting leave? Is this 2 calendar days or Sunday, or is this 2 work days, Friday?
Yeah, because elections are you're generally talking about a Tuesday. I don't know of any firm guidance, but most of our employers have been requiring that leave by the Friday prior to the election. So that would be essentially 2 work days. Again, being conservative in the absence of some guidance. Otherwise, most jurisdictions that I'm aware of are requiring that leave request to be in writing as well. So in writing by the Friday before the election, if the election is on a Tuesday, not requiring leave over the weekend, which would be arguably problematic for the employee or cause some confusion.
Okay, we are at our hour and our allotted slot time. But let me ask one final closing question dealing with marijuana. I guess it's sort of a 2-part question. The first part is, if an employee tests positive for marijuana on a random drug test, if an employee on medical marijuana tests positive in a random drug test, thoughts on that, on how to handle that in the workplace?
I've just had this come up in the past week or last week. My feeling on it is if it's medical marijuana, you have to engage in the interactive process with the individual. You got to do some due diligence, some digging to find out, you know, when is he or she taking the medical marijuana? Is it affecting their ability to do their job? Or is it something, again, where they are taking it for their disability when they get home? And of course, the random drug test comes up and it says that it was a positive. So it's, unfortunately, it causes you a little bit more work where you got to dig into it and find out from the employee whether or not it is something that you need a reasonable accommodation, and what's the accommodation, that you're not affecting your policy, which says you cannot, if you have a positive drug test, you know, you're 1 strike, 2 strikes, whatever it is. So that's my thoughts. It's an evolving sector right now, this medical marijuana. But that's my thoughts, at least in terms of how the law applies to this.
Finally, on that question, if marijuana is legalized in the state of New York in 2020 or beyond, does the county have the right to institute a drug test going forward? Does that depend on the type of job, or is that subject to a collective bargaining agreement?
Geez, that's a really good question. I would say it's to be determined. We would have to, you know, there's a lot that's going to come about if and I guess maybe when marijuana is legalized. But I do definitely think that the employer still has the ability to regulate whether or not it affects the workplace and the ability of the person to do the job.
Okay, let me thank our folks, our speakers today from Roemer, Wallens, Gold, and Mineaux, Earl Redding, Matthew Ryan, and Elena Pablo, and our presentation on hot topics in public sector labor relations. We will have this posted on our website at the end of the day. Thank you all, and I hope you all have a great day and week. Thank you.